Well, I'm back, and once again, I'm apologizing for the technical difficulties of getting everybody onto the webinar, and particularly for those of you who were on, and then I had to kick off to permit others to come on. So thank you very much for your patience. Okay, so we're going to start over again. My name is Steve Holden. I am going to walk you through the Dynamex decision today. For those of you who've already heard this spiel, I apologize, but wanted to mostly say that the reason we do these webinars is because we really care about our clients and want to make sure that you have some proactive information that you can use to help minimize the potential that you're going to be involved in any kinds of claims or litigation. Because although we do the defense of those things, we know it's not a happy place to be for anybody. And the whole purpose of the webinar is to give you good information to avoid that. And I want to have a special welcome to all the InterWest clients. InterWest asked us to open this webinar also to their clients, given the importance of the information. And as many of you know, we have a very, very long-standing and close relationship with InterWest, which is a terrific organization that also cares very much about their clients and making sure that their clients have all the information and tools to be successful. So as I said previously, I've been doing this a long time with the sole focus of representing employers. And in doing that, get lots of information about all the cases that come out of the California court system and the federal court system in our jurisdiction. And that's literally hundreds of cases every year. And we go to conventions, we have MCLE, continuing education courses, magazines that outline all those cases. And so spend a lot of time looking at the individual cases that come out regularly from the court system. But the great majority of those cases have little impact to no impact on the day-to-day of your operations. They might make us better attorneys. They may give us nuances that assist us in providing more focused and effective guidance, but they're not going to change your operations. The Dynamex decision for many of you will. It is that significant. It is groundbreaking. It's momentous. Whatever other hyperbolic phrase you want to put to it, it is that significant. And so the purpose today is to walk you through the Dynamex decision and give you some guidance on what to do next. So let's start with the game plan of what we're going to do today. I'm going to start by giving a little background and history on the law that pertains to the difference between an independent contractor and an employee. And you'll see on the screen the IC/EE, IC, independent contractor, EE, employee. Those are my little abbreviations. I'll explain the Dynamex decision, and then we'll talk about the significance of it and the complexity that it's going to create. And you can see on number 3, which test applies is one of those complexities. And so we'll walk through what it means in terms of the various areas of employment law. I'm going to give you an example of liability with some real numbers so that you get an idea of the significance from that perspective and what we're trying to avoid. And then I'm going to do a couple of different contrasting job descriptions or examples to walk you through how you might go about doing the analysis in a very quick and dirty way. And then I'll have some recommendations for you, and we'll then take Q&A. And this is about where we got before we had to reset. And so on your screen, you should have a place where you can type in questions. I encourage you to type in your questions. I have some staff that will be getting those questions and pulling them off for me. And at the end of the presentation, be taking as many of the questions as we can that you may have related to Dynamex and what's next. So let's jump into the background and history. First, thing to know is that courts have struggled with this particular question of whether somebody's an independent contractor or an employee for a long time. In fact, here's a quote out of a U.S. Supreme Court case from 1944. Few problems in the law have given greater variety of application and conflict in results than the cases arising in the borderland between what is clearly an employer-employee relationship and one that is clearly of independent entrepreneurial dealing. And it is those borderland cases that go in helter-skelter directions. So you'll read one case, court comes to one decision, and another court in another county, or in some cases in other states, go in a different direction. So that's what the court is referring to as they've had difficult time for decades of deciding exactly how to handle this. Initially, the test was called the control of details test, and wasn't always called that. And one thing you're going to see when I talk about tests, the same tests get named different things by courts or by commentators. The control of details test, also commonly referred to as the common law test, and it's had other names as well. But it had its genesis with regard to torts, with regard to negligence and personal injury and that sort of thing. And the idea was that it was unfair to hold the hiring entity, the person who hires the worker, responsible for what that worker does in terms of injuring a third party, unless the hiring entity controlled the details of that worker. And if they controlled the details of the worker, then we were going to hold the person who was controlling the details responsible for the results of the worker's actions, injuring somebody else. Well, what happened is the courts looked at that and said, yeah, but that doesn't work all that well when we're talking about social welfare legislation. Laws like unemployment insurance, laws like Social Security, or things like that, which were enacted as a social welfare program or for protection of employees or workers. They didn't like the control of details because it didn't get enough people swept into the social welfare legislation, so they added secondary factors, and we'll go over a number of those secondary factors. And so you looked at who was in control, but then you also looked at these secondary factors. Out of that, we've developed also another test, which is called the economic realities test. It's another way to look at the relationship of what does it really look like economically? Does it look like two separate businesses, or does it look like a employee working for an employer? And on top of that, we have hybrid tests that courts have put into play. And so if you look at all of the case decisions over this, the courts have used a variety of different tests, a variety of different labels, all until, and currently to today. And then we now have, as of April 30th, the Dynamix decision and the ABC test, which is brand new for California. So that's the history of the various tests and law as it relates to independent contractors and employees. As I mentioned, the courts added a number of factors when they started to look at this question of who's a contractor, who's an employee. You may have heard of the IRS 20-factor test. That was one of the first tests where we started to refer to the number of factors. There was a period of time where EDD in California was using a 24-factor test. Typical for California is if the federal government can do it one way, we can do it even better by adding more to it. So they added some additional factors. You can see on the screen, I don't have 24, I don't even have 20. What I did do was summarize some of the key factors that are utilized. The question is, who is the hiring entity or the alleged employer supervising and training the worker? If so, it's more likely employment. What's the degree of skill and experience that's required for the job? If it's a highly skilled job, maybe more likely to be an independent contractor than a very low skilled job. What's the permanency or duration of the relationship? Is this something that is going on indefinitely, or is the alleged contractor coming in, doing a job for a few days, and leaving? Does the hiring entity have the ability to discharge the worker at will without any consequence? Is the work that's performed integral to the hiring entity's business? Is it a key component of the hiring entity's business? Does the contractor, alleged contractor, have a separately established business? They actually provide the same kind of work for others? Does the alleged contractor market themselves, have a business license, those types of things? The next is to look at what's the opportunity for and risk for profit and loss. Does the worker have the opportunity to control their own risk of profit and loss by their ingenuity, their efficiency, or are they just getting a paycheck? Next, you look at the alleged contractor's investment in starting this business, in their equipment, their facilities. Who's paying for that? Is it the hiring entity or is it the alleged contractor slash worker? And then, is the work that's performed by this alleged contractor, is it also being performed by employees of the hiring entity? That would certainly indicate more of an employment relationship than a contractor relationship. Next, they would look at the method of and timing of payment. Are you just getting an invoice and paying a flat fee to get the result, or are you paying by the hour or by the piece? And then finally, they would look at the alleged contractor's understanding and intent. And the courts have made it very clear that although they look at that and they want to know what that is, it's not determinative. So you can't just agree with a worker to establish an independent contractor relationship. So although later we're going to talk about having a written agreement, it is critical to understand that even though it's a factor here, and I'm going to recommend that you have a written agreement, you cannot agree with a worker and by your agreement create an independent contractor relationship. You have to meet the legal test. You have to, in essence, get a court to go along with your decision. All right, so that is the history and a little bit of the tests the factors that are used in the multi-factor tests. So let's talk about Dynamex. So Dynamex was a complaint that was originally filed on April 15th, 2005, almost 13 years ago. The lawsuit was initially filed in the Superior Court, and now it's up at the California Supreme Court being decided. And that doesn't mean after 13 years that the case is over, because it still needs to go to trial. The Supreme Court really just answered a preliminary question regarding the certification of the class action. So as you can see, it was a class action, and it was a class action brought by a couple of drivers for Dynamex, which is a delivery service. Dynamex offers on-demand, same-day pickup and delivery services, and they did it in a variety of different ways, and I think they had some other services as well. So let's talk about the relevant facts, and you'll see I pulled out the facts from the case that relate to those factors that we just talked about. So prior to 2004, the drivers were actually employees of Dynamex. In 2004, all of the drivers were converted to independent contractor relationships and entered into independent contractor agreements because management at Dynamex decided it was going to be more profitable to do that. Flag number one and very red is converting an employee to an independent contractor. The drivers were required to provide their own vehicles, and they had to pay for all their own expenses like fuel, tolls, the maintenance on their vehicles, liability insurance for their vehicles, etc. But Dynamex was responsible for obtaining the customers and setting the rates that would be paid for the deliveries. The drivers then were paid either a flat fee or a percentage of whatever the delivery fee was that Dynamex got from the customers. The drivers could set their own schedule, but they had to notify Dynamex the days that they intended to work. Some of the drivers were required to obtain and pay for, as one of their business expenses, a specific cellular telephone through which they could communicate directly with Dynamex to get dispatched. They were assigned their deliveries by Dynamex dispatchers. The drivers had no guarantee over how many or type of deliveries that they would be offered, and they didn't have to accept them if they were assigned one, but they were required to promptly notify Dynamex that they weren't going to accept the delivery. The drivers were expected generally to wear Dynamex shirts and badges, so logoed apparel, and with certain Dynamex agreements, the drivers had to also attach those metallic decals to their vehicle that had either the Dynamex logo or the customer's logo on it at the time they were making the delivery. The drivers, if they purchased the Dynamex shirts and other things, they would pay for that themselves. And they were free to choose the sequence and routes they used, but they were required to get all of the deliveries that they were assigned within the day's assignment that they came in. The drivers could hire others to do the work for them, and they could do deliveries for other companies if they chose to do that, or create their own personal delivery business, as long as those two things didn't compete with Dynamex. And they were hired for an indefinite period of time, and Dynamex could terminate them with 3 days' notice. So if you look at all those factors, even before the Dynamex decision, those of us who've dealt with independent contractor law would have said, oh, you're barking up the wrong tree to try and make these people independent contractors. And that's partly because in the transportation industry, the whole conversion of employees to independent contractors is something that is now decades old, that was tried first, and I cannot remember the name of the company, but it was a very successful delivery service that was the precursor to not FedEx or DSL, but one of those, and that was out of the Midwest. I want to say Cleveland or Columbus, Ohio or something. And they were the first to come up with this idea of, boy, it would be a lot less expensive if all of our drivers weren't employees and they're independent contractors, and they started this conversion. Well, what followed was waves of litigation that has been going on in this in that particular industry, and almost all of it has been negative towards having delivery drivers be independent contractors. So in the Dynamex decision, what the California Supreme Court was tasked to do is to answer the question, what is the proper test for deciding whether somebody is an independent contractor or an employee under the California wage orders? As many of you know, the wage orders are those kind of separate body of law that deal with wage and hour law and that apply in California. Well, the reason that they were looking at this is because the definitions of what it means to employ or be an employer under the wage orders are not identical to the definitions of what it means to be an employer, to employ, or to be an employee that you might find, for instance, in the labor code or in other employment-related laws. In particular, what happened in the Dynamex case is the lower court had decided that the proper definition of employ for the wage orders was this engage, suffer, or permit to work, just exactly what it says in there. And as a result, certified the class action based upon that. The lower court also said that that definition, however, was not the proper definition to use when they were looking at labor code violations, because in this case there was also a claim that the drivers had not been properly reimbursed for their expenses under Labor Code Section 2802. And what the appellate court said there is that really is still going to be under what we call the Borello test. In any event, the court looked at that and said, well, if you look at what it means to engage, suffer, or permit to work, if you just went out and hired an electrician to come put in a new wall socket for you at your office building, you would be engaging that electrician or electrician's company to work. And that definition is so broad, it sweeps in everybody who does work, including those people that we've always thought of as being the stereotypical independent contractor. And so the California Supreme Court said, no, we think that's too broad. And so what they did then was start looking for a test that met what they felt were the appropriate test for the wage orders. And it was interesting that this language in the wage orders of employ and employer date back apparently to 1916, and they hadn't been effectively looked at by any court until the Martinez decision in 2010. And I frequently tell clients, hey, this is just a new example of the new wave of wage and hour class actions and claims for, as you can see, decades from the early part of the last century into the first part of this century. There wasn't all that much going on when it comes to wage and hour stuff. In recent decades, though, it's at hyperspeed that plaintiffs' attorneys and employees are looking at the minutia of wage and hour law. So let's talk about the ABC test. What is this test that we now have to deal with, and is the test for deciding whether a worker is an independent contractor or an employee for purposes of the wage order? And here it is. A worker is properly considered an independent contractor to whom the wage orders do not apply only if the hiring entity establishes that the worker is free from control and direction, both under the contract and in actuality. And then next, B, the worker performs work that's outside the usual course of the hiring entity's business, and the worker is customarily engaged in independent trade, occupation, or business. So let's look at that just a little more closely. Look at the first part of this. Now, they could have said it another way. They could have said that to be an employee, I should say, they could have said everybody is an employee unless the hiring entity proves, and you notice that the burden of proving that somebody is not an employee, but rather an independent contractor, is on the hiring entity. It's on you, everybody I'm talking to. So how that'll actually play out in various claims where, generally speaking, the person who's pursuing the claim, the employee, has the burden of proof, will be interesting to see on whether this language actually reverses the burden of proof and puts it onto the employer. At a minimum, I expect that there'll be a presumption that everybody is an employee until you carry your burden of proving that they're an independent contractor. So let's look at the first factor. The worker is free from control and direction. That, if you want to go back, we talked about the very first test was this control. And in all of the tests, the primary thing that a court or a government agency is going to be looking at is who is in control. And this factor of the ABC test, the A factor, really gets to the essence of that. And there's two important things to know. The control has to be both under the contract for performance. What's your agreement? The agreement has to provide for that freedom of control, and it has to exist in fact. So if you have an independent contractor agreement and it says that the worker has total control and the hiring entity just a result, it is going to be, that's what you need in the contract, but it's going to be meaningless if that's not what's happening on the ground and that's not the actual relationship. So it has to, that freedom of control has to be in both places. The other thing that is critical to know about this element of control and direction, it doesn't have to be exercised. If I'm the hiring entity and I possess the right and ability to control and direct the worker, but I don't do it, I just let the worker do whatever they want to do, it's still my employee because I have the right and ability to control. It's not whether you control, it's whether you have the right and ability to control and direct. Okay, so let's look at the next, and this is the monstrous element in my view that is completely new. It was a factor that was looked at previously in the factors test and still would be under the factors test, but it basically says that if the worker is performing what you do in your business, they can't be an independent contractor. So the worker has to perform work that is outside the usual course of the hiring entity's business. Okay, very significant. And then finally, the C test. And let me go back. Notice that it's an and at the end of the B. You have to establish all three of these. You have to establish A, B, and C, not just one of them. And then the C test is that the worker is customarily engaged in independently established trade, occupation, or business that is of the same nature of what they're doing. So for instance, if I had a plumber, had a plumbing business, big plumbing business, and they came and did some plumbing for me here in my law office, I'm probably okay in terms of not having that be an employment relationship with the plumber. But what if I had the plumber come and do some landscaping work for me? I would fail this test because the plumber's not a landscaper, and in that landscaping function, they're likely going to be deemed an employee. All right, so that's the test. So what's the major impact? Well, first, the major impact is we have a new ABC test for wage orders. There's secondary impacts, however, of the Dynamex decision. The first is, well, what's going to happen with labor code violations? The court specifically said they were not going to address that question, and they left the Court of Appeals decision that the Borrello test being a multi-factored test that you'll see that we use in a variety of places in California for purposes of labor code violations. So what if that remains the law? And the reason they did that, let me back up, is because of the way the case came to it procedurally. But if that remains the law, we have certain things that are both in the wage orders and the labor code. For instance, the meal periods are in both places. It would mean that there could be a meal period violation that you would have under the labor code, under the wage orders, but you wouldn't under the labor code because the tests are different. So there'll be some confusion that comes to that. And honestly, what I think is going to happen is courts are going to gravitate towards this third significant impact here, and that is the statutory purpose standard. The court in Dynamex said, hey, when people have been talking about the Borrello case, they've been talking about it as a common law test. Well, that's not what it is. It's really the statutory purpose standard. And what's critically important is when you're looking at all these factors, including, the court said, out-of-state cases, you're looking to figure out how to best effectuate the underlying purpose of the statute. And if the underlying purpose of the statute is to give, for instance, workers who are not working benefits through unemployment, well, then it's going to naturally lean towards an employee. So how that language impacts future courts at a lower level in using the old test, to me, I think is going to be significant, and I think things are going to gravitate toward being more like the ABC test, which essentially means way fewer legitimate independent contractor relationships. And the last thing that's significant is that the court didn't discuss whether its decision was retroactive or not. In other words, has this always been the law and they're just explaining to us what has always been the law, or is this new law that they're creating that would then only be applied prospectively? Don't know the answer to that. It is my understanding that a request of the Supreme Court has been made to clarify that issue, so we may get some guidance on that. Okay, so which test applies? This is part of the confusion I was talking about. So under workers' compensation law, whether you're in a contractor or employee, the Borrello test, which is another California Supreme Court test, which uses the multi-factors. You look at all the factors, you don't apply them in any formulaic way. You apply them in the context of your situation to see if it looks more like an independent contractor relationship or if it looks more like an employment relationship. Under EDD, state tax and benefits, they use what is sort of a common law, kind of like Borrello, and has some factors to it. As I said, there was a period of time where they used a sort of a 24-factor test. Now they have a guidance that uses right of control as the primary and main focus, and then they've got 13 factors that they look at as guidance. Federal, again, used to be IRS looking at 20 factors. Now they've kind of repackaged it into these three broad factors of who's got behavioral control, who's got economic control, and what's the type of the relationship. Under the Fair Labor Standards Act, the federal equivalent of what we're talking about with the wage orders and labor code, we use an economic realities test, which is somewhat different than the multi-factor test, but in other ways it has a lot of similarities. Well, now we know under the wage orders we have this ABC test, which is significantly different. And the significant difference is if the worker is performing the same kinds of things that is part of the hiring entity's business, then there's no way they can be an independent contractor. And then arguably Borrello still is the test for the labor code, but as I said, I could see that potentially gravitating away. So you might say, it's no big deal. In fact, I had a client that essentially was taking that position with regard to Dynamex. And they were in the sense that they only had one person that they intended to convert, and they were converting an employee to an independent contractor relationship, and they wanted to have an agreement to go along with that. And they made the decision, well, it's not going to be that big of a deal, it's just one person. So that led me to put together this next slide to show you what the potential liability for a single employee might be under this new standard. And it's if you were to get it wrong. Now, mind you, a lot of these things that you see here are labor code violations, and so it gets more complex of, well, which penalties are going to apply and all the rest of that. And I won't get into all of that. But if you start to look at PAGA, which we haven't talked about today, but PAGA is the Private Attorney General's Act, which is an act that gives employees and their attorneys the ability to bring statutory claims as if they were the government, which opens up the whole playbook of essentially the labor code, the wage orders, etc. You start to add all of these various penalties or violations when you misclassify somebody. So if you classified somebody as an employee, as a contractor, but they were in fact an employee, you wouldn't have done pay stubs correctly. You wouldn't have paid them on a timely basis the way you're required to for employees. There's a penalty for willfully misclassifying employees, which after the Dynamex decision is going to be a lot easier for plaintiffs' attorneys to make. You won't have probably given them any kind of paid sick leave. You shouldn't have if they were truly independent contractors. You didn't reimburse their expenses, and you shouldn't have if they were independent contractors. And you weren't giving them any meal and rest breaks. So if you assume you had somebody who's exempt, mind you, you didn't classify them exempt, non-exempt. They were an independent contractor. But let's just say they were doing something where we could get them in to an exemption, and the equivalent that they were making was $40 an hour. For that one person, their liability would be $147,050. And I didn't look very hard. There's a bunch of other labor code sections or other violations that I could come up with. But the kicker is the tiny words at the bottom, plus attorney's fees and costs, because they become automatic in wage and hour law, generally speaking. And let's assume that this person was not exempt and they were paying $40 an hour. The overtime exposure on that, if they only worked 2 hours a week of overtime plus the penalties, you add another $84,000 to this. This is just for one employee and me manufacturing some claims and putting the penalties on top of each other. Imagine what that would be like if you misclassified 3 or 4 people that are all in the same job or more. So this is to give you an example that because of the nature of the way our wage and hour liability exists and the penalties that go with it, there's plenty of incentive for plaintiffs' attorneys to even bring individual claims. It doesn't have to be a class action. There's enough money there to incentivize me to come after you for one misclassification. All right, so let's talk about a hypothetical where we do the analysis. And the hypothetical is this. I have a law firm, the Holden Law Group, and we practice employment law, and we support employers and try to help them not get in trouble and do positive things and that they do for their business and in their nonprofit missions. We have a couple of restrooms and they have sinks, and one of the sinks faucet is broken. So we call ABC Plumbing Company. Oh, that was a Freudian slip to say ABC Plumbing Company, XYZ Plumbing Company, and ask them to come fix our sink. So if we look at that situation, supervising training, we don't provide any. Degree of skill and experience, yeah, the plumber needs to know how to fix the faucet, and I don't know how to do that. Permanency and duration of relationship, they're here for an hour or two and gone, and that's the extent of our relationship until the next problem arises. Can we discharge them at will? No. If we have them come and we say go away, we're probably going to get a service charge for that. Integral to our business? No. Does the plumber have a separate business that is established? Yeah, they've got trucks, they've got logos, they advertise, they've got a website. Do they provide work to others? Sure. As soon as they leave here, the plumber's going to go 2-3 more jobs before they end their day. Opportunity for profit and loss risk? I don't control that. The plumber does. They set their price. They figure out how many jobs they can do in a day, what they pay their people, etc. The alleged investment, they've got trucks, they've got tools, they've got materials, all that kind of stuff. I'm not putting up any money for that. The work, is the work also being performed by my employees here at the law firm? No, none of our employees do any kind of plumbing, so we're make that that fits for independent contractor. Method of payment, they send an invoice, we pay them a flat fee, we don't pay them by time or the piece. And then what's the understanding? Our clear understanding is that they do not work for us and that they're a contractor. And is the work outside the usual course of our law firm? Of course, we don't do plumbing. We do labor and employment law and human resource consulting. Okay, let's try a different example. Holden Law Group is still the example. Now, we don't do this at the Holden Law Group, but there are firms, and the modern way to staff a firm is to have the attorneys be contractors, not employees. So we'll use us as an example, but this is not how we staff. But let's say we did, and instead of the attorneys who are helping you being employees of the Holden Law Group, they are actually independent contractors that I have a contracting agreement with. Well, do I supervise and train them? That's going to vary depending upon the level of experience and skill. But let's just say I don't. Okay, that makes it look like it's an independent contractor. Check the box. What about the degree of skill and experience required? Typically for a lawyer, that's going to be fairly high, and so that will probably favor independent contractor status. What about the permanency and duration of the relationship? Well, the firms that are doing this, the idea is this is an ongoing relationship. There is no end to it until something goes wrong. So that looks more like an employee relationship. Can you discharge at will? Can you just say, hey, I'm done with this. We're not going to be having this relationship anymore? And the answer to that is typically the agreements would say that, and that looks more like an employment relationship. On and on through these factors. Now you can see through these factors that gives you a mix. Some things look a little bit more like an independent contractor, some things look a little bit more like an employee. But look at the one at the bottom in red. The work, is it outside the usual course of the hiring entity's business? If I have a contractor who's an attorney, they're performing legal work, it is not outside the course of our usual business, it's right in it. As a result, I cannot meet the B factor of the ABC test. I'm done. They're an employee for purposes of the wage order. And that factor is going to significantly change many of the independent contractor relationships that exist today, where to get your normal and usual work done, you do it through contractors. Okay, so what are the recommendations? Well, first, analyze any contractor relationship extremely carefully. And you may have already done this. You're probably, most of you, extremely diligent in terms of knowing about independent contractors and employees, and you've looked at your people and you've made calculated decisions on those ones that are borderline or wobblers, and you've decided, hey, well, we feel good with this, or we're willing to take the risk with this particular classification and as a contractor. Keep in mind, the government does not want any contractors, virtually none. And the Dynamex court even alluded to that. And so you always are starting from the downside if you're trying to say this is a legitimate independent contractor relationship. So analyze them very carefully, look at the ABC test for the wage orders, and just know that, if you can't make those three factors, they're an employee for purposes of the wage order. But the bigger concern is that courts, as they apply the other test, the Borello test, or the test that is the behavioral test, I can definitely see courts pulling in more of the influence from Dynamex and moving further towards an element like the B element in the ABC test, which is going to mean there are going to be fewer legitimate independent contractor relationships, even outside of the wage order context. Step number 2, if you are going to continue with your independent contractor relationships that you have, or you're going to enter into a new one going forward, make sure you have a good written agreement. Because remember, the A factor requires that there be a in fact agreement and in fact practice of this absence of control. So you want that agreement to reflect the relationship. But once again, keep in mind, the agreement, although you have to have it and you want to have a good one, does not mean you have an independent contractor relationship that will survive the scrutiny of the courts. And then next, you need to monitor the work and make sure it's going in accordance to the agreement. Because if it isn't, and your agreement says no control, but every day all you're doing is controlling the worker, you're not going to have a legitimate independent contractor relationship. And then next, if you are deciding, hey, we've got some people that are not going to meet the test anymore, and really they need to be employees for purposes of the wage order, we're going to convert them to employment. That's fine. You're not going to have any exposure going forward, but depending upon how you roll that out and communicate it, we don't want to highlight exposure that we might have had going backwards, depending on what we learn about Dynamex in terms of whether it's retroactive or not. So I appreciate you hanging on as we flew through that. We will take some questions, but because of our difficulty, we probably won't get as many before you were planning to leave. I will stay and continue to do this for at least a few more minutes so that you get your money's worth. So the first question we have, do all of these factors have to be one or the other to establish independent contractor or employee status? No. I think if the question is, if you go back to my example here, do you have to have all of the factors be in one column like we did here? The answer is no. You could have a mix where the factors looked for more like independent contractor and another factor looked more like employee, and it's the total package that the court would be looking at to decide. Now, in this particular example, the attorney example, for the purposes of the ABC test, they're not going to be looking at all these factors. They're going to be looking at that bottom line, the one in red, and I don't meet the B factor or the B part of the ABC test, so I'm done. It doesn't matter what the rest of it looked like. If on this chart all of the X's were in the IC column, but this last ABC B factor was where it is here, I lose. It's an employee. Okay, let's see. Next question. What does customarily engaged mean? Example, I work at a university and we have professors speak to classes as guest speakers. They are chiefly professors that from time to time speak to students. Would this count as an independent contractor or no, because we hire instructors? So for purposes of the ABC test under Dynamex and the wage orders, if you bring professors in to speak to or give classes to your students, they're never going to meet the B factor under the ABC test, because teaching students is the usual course of your business if you're a university. So I don't think you even have to, I hope that answered that question. Let's see. We have one independent contractor we will be converting. How much notice do we need to give? You don't, the law doesn't require any specific notice. I think that becomes part of your strategic plan of what you're going to communicate to the person who has been a contractor. And I think for most people, that strategic communication is going to make specific reference to Dynamex. It makes sense because it gives us a jump-off point to say, well, before things were fine, now the court has created this new test. Under the new test, we have to make a change. Now, I'm not suggesting to you that's the right strategic communication for all of you. You're going to want to take a lot more things into consideration when you decide what you're going to communicate to an individual worker who you're moving from contractor status to employee. And part of that is to look at what benefits or the opposite of benefit, detriments, excuse me, to that worker going to be by the classification and the personality of that worker, and take those into considerations in deciding how you're going to communicate the decision. But there is no specific notice period that's required. Next question is, what about corp to corp agreements where the agreement is with another employer / vendor to use their employees? Well, this sounds like it could well be a situation where the law having to do with joint employers would come into play. And if that's the case, I made a very brief reference to the Martinez decision, which the Dynamex court talked about quite a bit. It was a decision under the wage orders dealing with the notion of joint employment. And as I pointed out, that court used the very broad to engage, suffer, or permit to work. And so in this context, whether you might be a joint employer is likely going to be controlled by that standard, which is arguably broader than the ABC test. Let's see. Here's the next question. Can we have the independent contractor sign an indemnification agreement in the event we get sued? That's a good question. And the answer is you probably can. The problem is that if they're determined to be an employee, by law, you can't get indemnification from them. So it's probably not going to be effective. Now, might you, going back to the previous participant's question, if you have a relationship that is more in the nature of a true vendor, or just a legitimate independent contractor agreement, like the example of the plumber coming and fixing our sink, might you want to have an indemnity provision in your independent contractor agreement? Definitely, yes, you would. But would it be effective if a court were to say, okay, I see your independent contractor agreement, I see this piece of paper, but we don't care. This person is an employee because they don't meet the ABC test. Are you going to be able to get indemnity from that worker because you have that piece of paper? No, not if they're determined to be an employee. Let's see. Okay. How does this apply to hiring employees through a temp agency? That's a good question. That also is going to raise significant issues about joint employer. And as I mentioned, the Martinez decision is definitely, in my view, broader even than the ABC test. So you're likely to have some exposure. But if you're hiring employees through a temp agency, are you then classifying them as an independent contractor for your organization? I'm not sure if that's what the question is. If it is, you're going to look back to those three factors in the ABC test, and primarily that B factor. What are they doing for you? If you're bringing them in through a temp agency, you are typically, when I think of our clients, they're doing that because they need workers, they need bodies to do the work that they're specifically engaged in. So they're not going to be able to meet the B factor of the ABC test, that the work is outside the usual course of the hiring entity's business. For a general contractor, under what circumstances would a subcontractor not be considered an independent contractor? Wow, that's an excellent question. I wish I had a definitive answer to how the Dynamex decision is going to play out there. I would say this, there's the two different ways you're going to argue that is that I'm a general contractor. The usual course of my business is to put organization and planning to a construction project. The usual course of my business is not to do any plumbing. It's not to do any electrical. It's not to do any concrete work. That is always hired out from other people. And so that's not the nature of my business. Now, where that gets mushy for a lot of contractors is where you do some of the actual trade work with a general contractor, does some of the trade work with their own employees. Now you've made it a much bigger problem for you to then claim that's not part of the usual course of my business. Okay, let's see if we have one more. One question here is, what if the person we use refuses to be an employee? Well, that is an excellent question to re-emphasize the point that this is one of those many areas in employment law where the hiring entity and the worker don't get to decide what the relationship is. The law drives that. So you could have this agreement and a person say, I don't want to be an employee, I want to be an independent contractor. It's better for me if I'm 1099. It's better for me if I can be independent. But if they don't meet all of the factors, then they are going to be an employee for purposes of the law. And again, you may say, well, this person really wants to be an independent contractor. I trust them. They're not going to sue me and claim they were an employee. Okay? That's taking on some risk, but you may decide to do that given your relationship with that person. That won't matter, however, if EDD is doing an audit of your payroll and they don't see any payroll taxes or withholding for that individual where payments are going out. I hope that answers the question. I think what do you do if they refuse? I would say try to have some education. If you want to continue them as an employee, if you want to convert them to an employee, continue the education, discuss why you're doing it and whatnot. If you want them to be an independent contractor, then you've got to explore, can we change the relationship significantly enough to meet the test? Can we change what we do as a business so it's whatever they're doing is not part of our normal course of business? Is that possible? Maybe. So I hope that answers those questions. I once again want to apologize for the technical difficulty we had in getting people on early, and for your patience, and also for hanging on for a few extra minutes as we got into some of the questions. So thanks again. Hope you have a great rest of the week, and take care.